of a constitutional prohibition or constitutional rule of thumb against courts giving advisory opinions on abstract questions of law as announced. But it's also a common law principle. And it's also, and I won't repeat my learned friends for AfriForum submissions in this regard, but the point is made that the Equality Act creates civil liability for acts of hate speech and creates remedies arising from such acts. But it does so in the context of a dispute with actual alleged hate speeches over an actual alleged act of hate speech. And the jurisprudence on the act so far that has been referred to in this matter conforms to this pattern. My Lord, the Foundation said yesterday, my learned friend for the Foundation said yesterday that this isn't an abstract case. It's not there is a concrete dispute. There's a dispute on the papers, and as I understand it, the dispute arises because AfriForum was said to have had as I understood it, an unsatisfactory reaction to the flag waving that occurred on Black Monday. It says that it discourages this kind of thing, but as I understood the argument, it didn't stop these people who waved the flag. It didn't discourage them and tell them to put it away. And that this renders the case, this gives it, at least on the papers, a concrete dispute that requires resolution by this court. Now, my Lord, I would submit that that doesn't do it. It's insufficient to create a dispute that would allow this court to exercise its powers to declare that civil liability has arisen as a result of something that has occurred or that is likely to occur. And if I might give an example, and it's not on the papers, my Lord, and it's something that was recently reported in the press, and that's the Human Rights Commission's investigation into certain acts of alleged acts of hate speech made by Mr. Julius Malemba and another member of the EFF. It's been reported in the press. I just simply want to use it as an example, my Lord. The issue in that particular case was a statement by Mr. Malemba, and in essence, the quotation is that we are not calling for the slaughtering of white people, at least for now. That was the alleged act of hate speech. And the Human Rights Commission investigated this, and it said that is not hate speech because you've got to see it in context. And a very important contributor to that context is that Mr. Malema subsequently, in an interview, expanded it on that statement and said, not under my leadership will I call for the slaughter of white people, even though I cannot guarantee what will happen after me. Now, my Lord, by analogy with this particular case, it might very well be that someone might say, yes, but that's not good enough. That's not forceful enough about denunciation. We're not saying that if somebody did so call, somebody did call for the slaughter, not you, but somebody after you called for the slaughter of white people, that is to be denounced, that is something that would be hate speech, and that is something that is to be forcefully condemned. And what we need is to proceed to the Equality Court for a declaration that anyone who might say such a thing is guilty of hate speech. Now, I think the answer that would be given, or the opposition that would be taken to such a case, would be to say that the court deals with actual cases and not hypothetical ones. It deals with hate speech that has occurred and not hate speech that might occur, that might hypothetically occur. My Lord, to seek out hypothetical hate speech that might occur, however important it might seem to obtain clarity about whether it would constitute hate speech or not, would be to commit the error that was commented on by the Supreme Court of Appeal in the case of Stransom Ford. My Lord, it's not in any of the bundles, and I just simply want to take one sentence from it. It's Minister of Justice versus Estate Stransom Ford.
Spell that for me.
S-T-R-A-N-S-H-A-M-F-O-R-D, and it is reported at 2017-3, page 152 in the SCA.
Is it SA? That's South African Law
Yes, my
Report.
lord, it is. 2017-3 SA, page 152, Supreme Court of Appeal, paragraph 24. And your lordship will recall that that is the case in which the SCA deals with the application for a declaratory order in relation to assisted suicide. And at paragraph 24, the court quotes an American judge, who says that courts do not or should not sally forth each day looking for wrongs to right. We wait for cases to come to us, and when we do, we normally decide only questions presented by the parties. My lord, the FRK is a cultural organization. It promotes the Afrikaans literature, culture, and the arts. And it approaches the case from the perspective of the constitutional guarantee of freedom of speech. It says that it regards the upholding of that guarantee as essential to establish the conditions in which cultural production can flourish. That's its interest in this matter. It's not advocating for the display of the old flag, but it has a concern about what might be lost to the freedom of speech if the foundation was to succeed in obtaining its order. And in this light, I would submit that there's a further reason for the court not to invoke its powers under the Equality Act. In this case, because this is a case about expression. Moreover, it's a case about political expression. And what
just come back to say it's a case of art.
Sorry, apologies, my lord.
I hear you said it's a case of art and political expression.
No, it is a case about political expression.
Okay.
At the core of it is political expression. And it entails asking the court, and behind it the state, to declare what can and cannot be said. And that is precisely what the freedom of expression guarantee is intended to prevent. The previous regime, like all other authoritarian regimes, kept itself in power by exercising thought control over its citizens and establishing and policing what could be said and what cannot be said. And the freedom of expression guarantee in the Constitution sets its face against this. My lord, the relevant dictum in support of this is in the case of Mamabolo, and that is not, the case itself is not in any of the bundles, but the quotation that I'm relying on is in the bundle.
Isn't Mamabolo in the case?
Apologies, my lord.
I'm talking about Constitutional Court or SCA.
This is Mamabolo. It is a constitutional court decision.
I thought we've seen one of the bundles, but anyway.
It is in the bundle. It's quoted at numerous places in the bundle, but or perhaps I'm incorrect, and there is a citation. I'm relying just on page. If you look at page 23 of the bundle, my lord, of the Foundation's bundle.
That is the record.
Sorry?
Are you talking about the bundle of authorities, or are we referring to the record?
I'm talking about the bundle of authorities, my lord. The Foundation's bundle of authorities handed to me yesterday. I think it is in the Weber-Wenzel file that is in front of you.
That's the
that is the one I'm referring to.
The Human Rights Commission.
Thank you. Page 23.
Yeah. I'm there.
And at paragraph 26 at the bottom, my lord. Does your lordship have it? I'm referring to
page 23.
Paragraph 26 at the bottom is the dictum from Mamabolo that I'm referring to. It says there...
paragraphs are numbered? Did you say paragraph?
I said paragraph 26.
I thought you said page 26.
I said page 23, paragraph 26. I hope I have... My Lord, I don't have a copy of the bundles. Perhaps this is the cause of the confusion. I might have the wrong bundle.
Page 23, paragraph 26, I have.
Thank you, my Lord. My Lord, the dictum is this: freedom of expression, especially gauged in conjunction with its accompanying fundamental freedoms, is of the utmost importance in the kind of open and democratic society the Constitution has set as our aspirational norm. Having regard to our recent past of thought control, censorship, and enforced conformity to governmental theories, freedom of expression and the free and open exchange of ideas is no less important than it is in the United States. It could actually be contended with much force with public interest in the open marketplace of ideas is all the more important to us in this country because our democracy is not yet firmly established and must feel its way. Now, my Lord, the court, unquestionably under the Equality Act, does have a power to proscribe and impose civil liability for certain speech acts with the intention of inhibiting, of chilling such acts, of stopping them from taking place, or at the very least from discouraging them from taking place. But it is a power that must be sparingly exercised, and only when absolutely necessary, since the rule of thumb under the Constitution, the starting assumption, is that there is the maximum possible freedom of expression, particularly freedom of political expression. And if I might take your Lordship then to another case in that same bundle at page 176, which is the Masuku case in the Supreme Court of Appeal. My Lord, and what I'm relying on in particular is at page 180 of that judgment, or at least of that, under that pagination.
.180 of the bundle.
Of the bundle, my Lord.
Okay.
And it is paragraph 31 of the judgment.
Yes.
And my Lord, Masuku is dealing precisely with the right to freedom of speech in the context of the hate speech exception. And it says, in summary, the starting point for the inquiry in this case, and the inquiry in this case is precisely a case into whether a speech, a particular speech act fell within the hate speech exception or not. And the court says that the starting point is that the Constitution protects freedom of expression. The boundaries of that protection are delimited in section 16.2. The fact that particular expression may be hurtful of people's feelings, or wounding, distasteful, politically inflammatory, or downright offensive does not exclude it from protection. Public debate is noisy, and there are many areas of dispute in our society that can provoke powerful emotions. The bounds of constitutional protection are only overstepped when the speech involves propaganda for war, the incitement of imminent violence, or the advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. And my Lord, in the same matter, I just wanted to refer to a further dictum, in the same report, in other words, the Masuku judgment, paragraph 18 of Masuku. The Constitutional Court in the case of DA versus ANC is quoted. Paragraph 18.
Yes.
If society represses views it considers unacceptable, they may never be exposed as wrong. Open debate.
You said paragraph 18.
Yes, my Lord, of the Masuku judgment. Apologies, I don't have a page number.
Does it start with Citizen versus McBride? That's how I have paragraph 18.
Thank you, my lord. The quotation is this: if society represses views it considers unacceptable.
Well, I hear, but I'm not finding that. Is this the middle of that paragraph?
Yes. Apologies, my lord, then I will have to look it up.
No problem. Sentence number, that might help. I just want to get where you are.
Yes.
Do I have the right sentence when I say it starts with "in the citizen versus McBride"? Is that the right paragraph?
No, my lord, that doesn't sound true.
Because what I've done is, from the case you were reading, I paged back 2 pages. That's where I find paragraph 18.
Thank you, my lord. It's at page 178 of the bundle, at the very top of page 179, my lord.
Of 179?
Yes. And it's
right.
limiting.
So the middle of paragraph.
Exactly.
I found it. Yeah.
Thank you.
And that's a quotation.
It's a quotation from, yes, it is a quotation from the Constitutional Court in VA versus ANC.
Right.
If society represses views it considers unacceptable, they may never be exposed as wrong. Open debate enhances truth-finding and enables us to scrutinize political arguments and deliberate social values. This dictum, also what was quoted earlier from that case, my lord, I would submit, requires us to have faith in open debate, confidence in the marketplace of political ideas that was referred to in Mamabolo. Ideas that are wrong will have little currency in that marketplace. They will be devalued and they will be crowded out. And the same goes for speech that is, as the court in Masuku puts it, distasteful, politically inflammatory, or downright offensive. It is to be tolerated under the Constitution, at least tolerated by the law, in the expectation that it will gain no traction. It will eventually be crowded out by more meritorious ideas. That's the idea of the political marketplace of ideas. And I just want to emphasize, my lord, that toleration of offensive ideas does not mean that one has to meekly allow the expression of offensive ideas without comment. One has to put up with them and allow this to take place without pushing back against them and opposing them. And that's exactly what occurs. There are many examples as to what occurs in modern South African society when there is racist speech on social media, for example. Such speech is immediately countered and immediately pushed back against and stomped upon. It gains no traction. And that means that, for the most part, the marketplace, this political marketplace of ideas that is referred to in Mamabolo, can be trusted to deal appropriately with such speech, to put it in its proper place. It does not merit or require or necessitate state intervention. And the prospect, which the Constitution has set its face against, of the state picking and choosing what may or may not be said. And my lord, it's precisely the FRK's contention, its argument that this is already occurring. That the political marketplace has shown itself to be quite capable, well capable, of dealing with apartheid nostalgia. No one in this matter who's willing to come on record has threatened publicly to display the old flag in the future. AfriForum is not advocating for its display. It clearly thinks it's unacceptable. They said if someone brings an old flag to its events, they must put it away. The FRK is not supporting or advocating for displays of the old flag. They said that in its experience, the display of the old flags at gatherings, public or private, is virtually non-existent. It says it has no political currency. It is a terminally ill creature on the brink of extinction.
Are you quoting?
I'm quoting from the papers of...
Well, it will be helpful if, when you quote, I know where you're quoting from.
Yes.
Otherwise, I'm trying to write everything you're saying when it's there in the paper.
My lord, perhaps it would be simpler, my lord. It's in my head. And if I could just refer you...
I have your heads in front of me.
Thank you. I'm quoting from paragraph 6 of my heads, my lord.
Yes. Okay.
The point is simply, my lord, that it appears from the evidence in this case that old flag waving is unpopular and marginal speech. No one in these proceedings is willing to defend it. And that is the case, that has become the case, without the state placing its hand upon this issue by prescribing and placing the hand of state intervention in the matter at all. And the Masuka case, as well as those other dicta from the Constitutional Court, tells us also how the hate speech exception and the hate speech provisions of the Equality Act must be interpreted. My lord, if the order that is sought is designed to inhibit simply wrong or distasteful or unpopular or offensive speech, then it will infringe free speech. Because put simply, you cannot in one breath say that the right to freedom of expression encompasses the freedom to offend, and then say that the Equality Act imposes civil liability for offensive speech. It imposes civil liability for hate speech, and it's precisely the argument that hate speech is something different. It is something different from offensive speech. And offensive speech in the sense of something that is speech that can be safely left to the political marketplace to take care of. My lord, I want to now turn to the order that is sought by the Foundation. Foundation asks for a declaration.
Am I still in your head?
No, my lord.
Okay. That's fine. I'm with you.
My lord, thank you, my lord.
Yes.
The Foundation asks for a declaration that any gratuitous display of the old flag would constitute hate speech. And gratuitousness, it says, this concept of gratuitous, is a shorthand way of saying that it's any display that's not artistic creativity, academic or scientific inquiry, or reporting in the public interest.
Those are the words from section...
And those are the words from section 12.
Yes.
But I would submit that it is immediately plain that this cannot be what the Foundation is seeking. It is simply too wide. It's simply too wide because you need to know more. And you need to be able to interpret the act of display with reference to the meaning that is intended to be communicated by it. And the reason I would submit that, my lord, is that the interpretation of acts such as the display of a flag cannot be done without consideration of what they are intended to mean. To take an example from the philosophy of speech acts, my lord, if I look at my watch, I might be wanting to inform myself as to what the time is. There's no meaning there's no communication entailed in such an utterance. But if I look at my watch when my learned friend is giving his address, it might very well be that what I'm trying to convey, or what I might be understood to be conveying, is that he's gone on too long and that this thing must wind up, and can you please move things along a bit. In that case, it is a display, it is a gesture that is intended to convey meaning, and that could be reasonably understood to convey meaning. If I look at my watch and it's directed somehow at your lordship, and the idea is that these proceedings should have gone on too long and we should wind it up, then your lordship might very well say, or might be very well be inclined to say that that is an impertinence, I'm being rude in doing so. But the crucial point is that the gesture in itself is not the target of your lordship's ire. It would be the meaning, the sense in which you think I'm doing it. So if your lordship were to say, no one may look at their watch in this courtroom, that wouldn't be the proper target of what your lordship would be trying to prevent. You'd have to say, no one may look at their watch in order to point out to me that the matter has gone on too long. No one may rudely look at their watch.
I was about to say I would never... Anyway.
Yes. My lord, the whole point is that an act such as flag displaying is empty unless one has a sense, and one is trying to catch, one is intending to prescribe the probable intended meaning behind it. What effect are you trying to have on the listener? And the Foundation says that any display of the flag that is not scientific or journalistic or artistic is inevitably racist hate speech. But a single counterexample shows that it is not so. And that counterexample has been given by my learned friend for AfriForum yesterday, which is that if you display the old flag at an anti-racist demonstration, and then you proceed to vilify it, you proceed to stomp on it and burn it, that's plainly not something that would give rise to concern in this case. It's because one is not concerned about the display of the old flag without context. One is concerned with displays with a particular intention behind them. And that intention has been described by the Foundation and also by the Human Rights Commission as being nostalgic, to promote the apartheid regime and lament its downfall. If the target is gratuitous displays, and it's immediately apparent that that is simply too wide, you'll be targeting displays that do not come with the requisite intention. They do not come with the intention of the requisite racist intention to be able to fit comfortably within the intended target of the prescription. And in that regard, the FRK has said that, given the history of the perception of the old flag, there might be ways, it's capable of being conceived of. It's possible to think that there are ways of thinking about this flag which are not just celebrating apartheid. They're not premised on racial superiority and inferiority. There's other ways. You might be able to think of other ways in which it might be displayed that isn't intended to be racist. And it said in that regard that the flag was created in order to promote reconciliation between the Afrikaans and the English-speaking sectors of the population. And I think the Foundation has accurately, quite correctly pointed out that that's not a very promising project, to say to people of South Africa, please see this flag differently because it was created in order to bring white people together. It's not a promising basis
But
on which to
nobody
have such a
disputes
project.
that.
Sorry?
Nobody disputes that.
Yes.
That's a history of the flag. That was its intention.
Yes.
As I understand the Foundation, they said, look, it wasn't only the unity of those groups you are referring to,
Yes.
but it was also the exclusion of the group you are not talking about.
Agreed, my lord. Yes. Yes, there's no, I think that point
So
is very well taken.
you seem to be, all of you, on. You agree on that
Yes, I
point.
do. Yes, my lord, that.
So I don't think anybody can take away from the historical context
Yes.
in which the flag originated. I mean, that's the benefit of history, is that it's
Yes,
there.
my lord. Yes. I think it has to be accepted that makes the flag problematic. And perhaps always problematic, that you can never wash that stain from it. That it was established on the basis of white supremacy, and this explains the offence that it causes. I think one has to, that has to be accepted. There's no question about it. But if the flag, for example, was to be flown by old soldiers at the commemorative events for D-Day, which are upcoming, 75th anniversary of D-Day, this would, precisely because of the controversial nature of the flag, precisely because of that, perhaps, because of that inevitable problematic association that it has. If you were to do that, that would certainly invoke criticism and controversy. It would perhaps be a very foolish thing to do. And it would also be gratuitous in the sense that the Foundation contends for. It's not scientific or academic or journalistic. It's kind of a proud flying of the old flag because that was the flag under which the soldiers did battle. But I think we're plain that it's possible to construe this as not intended to promote hatred and incite harm. It might be wrong-headed, and it might be ill-advised, and it might be foolish, but it is not intended to promote hatred. And that is because context is crucial. One has to consider the context to indicate whether the probable intention and effect of the speaker is to cause harm, to promote hatred and incite harm is required. The Foundation is seeking a prohibition of displays of the old flag on which a particular interpretation has been placed. I would submit, my Lord. They say that old flag would always be displayed with the intention to promote the apartheid regime and lament its downfall. And that's really what is being, that's the message that they're trying to, that's the harmful message that they're trying to get at. A yearning for the good old days of apartheid. If one was to adjust the declarative that is sought to say that any display of the flag intended, or probably intended, that can be reasonably construed to establish an intention to promote the apartheid regime and lament its downfall, then that would narrow the declarator at least to the point where it is capturing exactly what is regarded to be the mischief in this case. Gratuitous, I would submit, the trouble with gratuitousness is not a good word.
Well, gratuitous, they didn't take it from the dictionary. They didn't take that act from
yes.
the legislation.
Section 12, yes.
I mean, hence my question earlier on to your colleague, to say legislation has said what hate speech need not be outlawed,
yes.
scientific and all those things. Hence I asked to say, what other display, given the apparent admitted hurtful effect of the display, what other display would you want? I think someone else yesterday, for what purpose do you want to display? So you say the display within the meaning which the applicants attributes the display for is problematic.
My Lord, I'm saying that
within the meaning,
real target
yes.
of the applicants, the problem that the applicants are trying to solve, the mischief that they're seeking to deal with, is not displays, but displays to promote the apartheid with the probable intention to promote the apartheid regime and lament its downfall. And I've given two examples of displays that would not meet that intention.
Yes.
And the difficulty is that gratuitous isn't then a good word.
Well, can we say displays which does not serve any of the purposes specified in the proviso?
No, the proviso is still too narrow, my Lord.
Well, do you want me to draft another legislation?
But, my Lord, that proviso is a proviso to Section 12 and
yes.
not to Section 10.
Yes.
Yes, so it is.
Now, but Section 10 specifically,
Oh, okay, apologies. Yes.
it specifically said subject
yes, no,
to that
quite
proviso.
Yes.
Yes.
Yes, it is. Yes. But
so if you think gratuitous is too wide,
yes.
can you say, look, if they were to limit their prayer to displays which do not serve any one of the purposes specified in the proviso?
Yes. It's still too narrow, my Lord, because the meaning, the purposes, not so much the purposes, but the meaning that is sought to be attributed in those examples that I've given is not, the proviso would not save it, in other words, because it's not artistic. So that example of the soldiers, the old soldiers, it's not artistic, it's not cultural, it's not scientific, and it's not journalistic.
I'm not sure what you said about the soldiers. It's not quite the
gave the
before.
hypothetical
You spoke
example,
about the
my
soldiers on D-Day.
I gave the hypothetical example, my Lord, of soldiers flying the old flag at the D-Day commemorations, because that was the flag under which they served.
Yes.
Now,
what did you say about that?
I would say that perhaps would be unwise, because the flag is so controversial and so offensive an object. But
that's not an example of what should be protected. It's not your example of
but precisely, but my Lord, that's where that is precisely what should be protected. Unwise, offensive, foolish speech is protected by the Constitution.
I see. Now I understand you now.
The final point is if that is so, and really what is being targeted here is not so much displays per se, but displays that are probably displays that are racist displays intended to indicate affection for the old regime and a desire for its return, then is that hate speech? In this regard, I would return to what was said in the quotation I drew your Lordship's attention to earlier from DA versus ANC. Society represses views it considers unacceptable. They may never be exposed as wrong. Open debate enhances truth-finding and enables us to scrutinize political arguments and deliberate social values. If that's the conception of the purpose and ambit of free speech, then it's very difficult to reconcile that with the contention that expressions of nostalgia from apartheid are excluded from constitutional protection. Such ideas deservedly have no currency, have very little currency and legitimacy. Both AfriForum and the FRK say that such expressions, symbolized by old flag waving, make them cringe. The foundation quoted, however, some of the demonstrators are saying that they flew the flag because they felt safer under apartheid. That's why they did it. Now, this is ill-considered. It's offensive speech. It's wrong speech. But it is speech that the political marketplace is very well able to deal with. You see the examples in this regard, my Lord, of how the government dealt with, responded to the display of the flags on Black Monday. And this is in the papers, in the bundle, in the record, my Lord, at page 60. I'll start at page 68. Do you have it, my Lords, under the heading Cyril Ramaphosa apartheid flag must never be hoisted again?
Now 68.
66, apologies, my Lord.
Yes, I have that.
Then Deputy President Cyril Ramaphosa has condemned the conduct of white farmers. I condemn those, and it's at the third paragraph under the photograph, my Lord. I also condemn those who participated in the march where they flung out the old South African flag.
Just 1 minute. You read the first paragraph, now you say I should go to the third.
It is, in fact, the fourth paragraph under the photograph, my Lord. I also condemn.
Does it say, yes, I'm there, I'm with you.
I also condemn those who participated in the march where they flung out the old South African flag. If they did anything, they damaged their own case, because by hoisting the old South African flag, they demonstrated to all and sundry in our country that they still hanker for the old days of apartheid, that they are still trapped by the racist past that we thought we had moved away from and that should be condemned. I'm hoping that flag will never be flown in South Africa ever again, and this must be the last time we've seen that flag. Page 69, my Lord, is the cabinet, the official cabinet response to the demonstrations, and particularly the flag issue. Paragraph, it is the sixth paragraph from the column on the left, my Lord. There were images that circulated.
Yes, I'm with you.
There were images that
coming out of the old SA flag debate currently taking place in the Equality Court in Johannesburg. The issues brought up there with regards to contextualization in which the flag is actually being used, as well as whether it causes or promotes harm. We're going to take a short break.
Past oppression or destruction of national symbols were dividing the nation and damaging social cohesion, the Cabinet said. Monday marchers had every right to protest the legitimate issue, but they also had to ensure it was done responsibly. The point that is that I would be making as on the strength of those articles, my Lord, and those responses, such speech is speech that the political marketplace of ideas is able to take care of, is able to deal with. We know very well what happens to people who express racist views online, expression of nostalgia for apartheid. They don't require the protection of the hate speech provisions, because hate speech is more than just wrong or offensive or misguided speech. It is speech that is so harmful and dangerous that it cannot be left to the ordinary marketplace of ideas. It is speech that is dangerous, it has a dangerous and attractive force. Can catch on, it can spread, it has the quality of propaganda in its ability to whip up hostility and to incite violence. My Lord, in the heads of argument...
Are you in your head?
Yes.
I said earlier on, it helps if you are reading a passage you want me to
This time I am
where it
reading a
came from
passage.
to
my
tell
Lord,
me
yes.
where it is.
Right. My Lord, I am at paragraph 22
Yes.
and 23 of my head. Lord, that quotes from an article by Waldron, who is an academic, seeking to put the point for the importance of hate speech protections to an American audience, an American legal audience, which regards the idea of hate speech protections as a strange and foreign concept because of the prohibition, essentially, the absolutism against the state being involved in the freedom of speech. And he puts the case for the necessity of such laws based on what he regards as their fundamental premise, the fundamental purpose that they're trying to protect. And at paragraph 22, my Lord, citing that article, the underlying purpose of hate speech laws is not that they are not a protection against offensive and unpopular speech, since that is constitutionally protected. Their aim is instead to diminish the presence of visible hatred in society and thus benefit members of vulnerable minorities by protecting the public commitment to their equal standing in society against public denigration. There's a quotation also from the Canadian court in Keekstra. The derision, hostility and abuse encouraged by hate propaganda have a severely negative impact on the individual's sense of self-worth and acceptance. And this impact may cause target group members to take drastic measures in reaction, perhaps avoiding activities which bring them into contact with non-group members or adopting attitudes and postures directed towards blending in with the minority. My Lord, the idea there is that hate speech, speech that requires special protection against and special concern, the law is entitled to be concerned about it because of its impact on vulnerable groups. Now one can well imagine that in vulnerable groups such as farm workers or labour tenants in platteland towns, witnessing a kind of upsurge in the display of old flags might very well fear the return of the old days. They might very well think that this presages some kind of return to the days of the past. But I think that's very different from a situation in which an old flag is hoisted on the sidelines or on the outskirts of an EFF march. Context is crucial, and the principal difficulty that the FRK has with what is sought here is the blanket nature, the all-encompassing and sweeping nature of what it is that the Foundation is seeking here. It lacks the essential attention that has to be paid to context, the context in which hate speech occurs, if it is to be said to reach the level that it requires protection, that requires the attention of the law to give protection against it. Thank you, my Lord. Those are the submissions.
Well, let me start off with one question. You've been long on context, and context is necessary. The context which has been built, in my mind, and whether that's sufficient or not, it's your duty as advocates to tell me. Yesterday there was much alluding to a historical context.
Yes.
What the flag, how it came about, who it united, who it excluded, and the myriad of other laws with which it was passed. The context which has been created in my mind also is of Selo Hatang, walking at Robben Island, showing tourists and the news flash of the display car. And he describes in some details the feeling and the emotions which came back flashing into his mind. That's there on the papers.
Yes.
I don't have to repeat it. And he says then, back at the office, a debate then comes with AfriForum, which leads us to where we are. The context of how he felt by just merely hearing about the display, is that irrelevant?
No, my lord, it's not irrelevant. It is precisely relevant to the determination of whether this causes hate speech.
Yes.
There's no question, yes. Or whether it constitutes hate speech. It's precisely relevant, yes.
Is that overstated?
No, no.
Is that the kind of feeling that anybody who was a victim of apartheid like he was
Yes.
would have in him?
Yes.
I'm just saying because we're talking context,
Yes.
to say it might be that what you're saying, they say we should talk about the future.
Yes.
But if we talk about the facts which have been presented to me and which have not been denied,
Yes.
I have to bear those in mind.
Yes. My lord, I think in the context of the case,
Yes.
in relation to the actual Black Monday demonstrations, that is what the case was concerned with, and it was seeking to impose civil liability under the Act for precisely those demonstrations. Then the evidence would go, it would be relevant evidence as to whether that constitutes hate speech. But we're dealing with a case of future, of all possible future demonstrations.
But this case arises from a context.
Yes. Yes, my lord, but it leaves that context behind and moves into the realm of the hypothetical and the future. And that's precisely the difficulty. There's no question that what happened at those demonstrations...
Do I understand your response then?
Yes.
To say that if the remedy was in relation to what happened then, you are not opposing?
Well, that is not the remedy that is sought.
No, I'm saying if.
That would be a different case, and it may very well be that if that was the case, the FRK would not be here. It's not particularly concerned with what happened on Black Monday. It's concerned with the future-oriented, the future-looking aspects of this case.
If the context was what happened on Black Monday, you would not oppose?
Well, I can't say, my lord, but that's off the cuff. I don't know what the instructions are.
I have one more question. Given the time that we all have time here,
Yes.
maybe it is appropriate time for us to take the adjournment and we'll come back at the wrap up. Quarter just?
No, it's going to go on. I mean, can I put my stuff let me just move to the side. Which one is it? Just
it's just in the middle. Thank you, Mandela. Might I ask, with your permission, that we split our reply for the foundation? I will ask Mr. Winks to speak briefly to the submissions made by Mr. Curry. He will really be short. And then I will speak for about 15 minutes in response to AfriForum.
Thank you. That will be accommodated. I promised Mr. Curry that I would have one more question. Then I come. And I see, looking through my notes, we have covered most of the questions that I intended to ask you. I would ask just one comment. This relates to the remark that the old flag has no political currency. In other words, there's nothing current about it now. To those for whom it calls back memories of suffering under its regime, the regime that it represented. Isn't that experience brought back and made current every time it's displayed? In other words, it's not just historic feelings. And back to what I put to you earlier on, when it was displayed, certain feelings come back. Is that not currency?
Perhaps, my lord, then the meaning of currency, as it was expressed in Ebarkar's affidavit, which is where the submission comes from, is really currency in the sense of marketplace currency, in the sense that it doesn't have value in the political marketplace, and that there's no one mobilizing under the banner of the old flag as though it has any kind of attractive force.
I understand. Thank you. Right, time to reply. Thank you.
My Lord, I'm indebted for the indulgence, and I've promised all of my colleagues that I'll be very brief. There are some key points in Mr. Curry's address that need to be corrected with respect. There's a suggestion that's been made yesterday and today that what the Foundation seeks to achieve is a ban or a prohibition or a civil remedy against offensive speech. Now, that has never been the case of the Mandela Foundation. The Foundation's case has been that there must be a remedy against dehumanizing speech, speech that degrades people within the meaning of Section 10(1) of the Act, speech that is hurtful, harmful, or hateful, not simply in a vacuum, but on the basis of group identity, on the basis of prohibited grounds. So it wounds people in their human dignity and equality. It wounds people based on membership of prescribed groups, on the basis of race, sexual orientation, disability, and the like. So it's not mere hurtful speech. And the euphemistic arguments to the effect that what is sought to be banned is merely offensive is, with respect, completely misplaced. As is the reliance in the last few minutes of my learned friend's address on R versus Keegstra. The suggestion and a very selective quotation from Keegstra that what is sought to be prohibited by hate speech laws is the kind of speech that causes an unbridled spread of hatred, when what that case very clearly was about, and very directly was about Holocaust denialism. It was about an academic who wrote papers in which he downplayed and denied certain aspects of the Holocaust, with no call to action, no incitement to anything. And that wounded people in their dignity and equality as a group. And that is what the law in the Canadian Criminal Code sought to address, and that is what the court upheld, is that it is permissible to curtail free speech to that extent, to protect people from being wounded in their dignity and equality. So that reliance is entirely misplaced, where you have Holocaust laws in many civilized countries in the world, laws against Holocaust denialism. Now we have a case here which in many ways is about apartheid denialism, behavior or messages that downplay or deny the harm wrought by apartheid and what came before it for 300 years. But what was done under the flag between 1928 and 1994 specifically. Now, the many arguments and authorities presented about the importance of free speech completely miss the point. At no point has the Mandela Foundation contended that free speech is not important. What is clear is that there are limits on free speech. And these limits are imposed by a variety of laws, by the common law of defamation, common law of privacy, statutory law on privacy. And if they go too far, then they get challenged and get declared unconstitutional. Here we have a law that imposes limits on free speech in Section 10, subject to Section 12. Now, what the FRK is contending is that there must be, of course, there must be limits on free speech. There must be a remedy against speech that defames an individual, but not, says FRK, a remedy against speech that dehumanizes a group, dehumanizes a whole people. Now, that can't be the case. For one reason, the legislature has decided that it can't be the case. The legislature has enacted Section 10(1). It imposes those limits on free speech. Now, there is no constitutional challenge to Section 10(1) before this court. So the court is only called on to determine whether the display of the apartheid flag, which in itself is a message, it's a clear message. On the papers, it's clear what that message means. Does that display fall within the crosshairs of Section 10(1) or not? The case in opposition to the remedy sought by the Mandela Foundation is not actually clear on that score as to whether or not it falls within the scope of 10(1). They concede it's offensive, they concede it hurts people, but what is unchallenged on the evidence is that it demeans, degrades, and dehumanizes groups of people. Now, my learned friend Mr. Curry said that we have to know the context. You can't decide make any pronouncement about what the flag means without the context. Now, the context is dictated by Section 12. Section 12 tells us the context, is that once you have a message of hate, a message that's hurtful, harmful, or hateful on the basis of group identity, then it's prohibited subject to Section 12. Section 12 says academic, artistic, or journalistic pursuits bona fide in the public interest. The legislature felt that you can use hateful messages within those confines. Now, Mr. Curry says that's too narrow. But then his grievance is not with the Mandela Foundation, but with the legislature, because the legislature decided that those will be the contexts in which messages of hate will be permissible. Now, the example of a reenactment of World War II D-Day, that may very well fall within artistic creativity. It's a theatrical exercise, but that's something this court doesn't actually have to determine, because if people are hauled to court for performing some kind of commemorative reenactment of a military deployment, then they can say, well, this is artistic. And if it's not artistic, then Section 12 is too narrow and we challenge its constitutionality. But they haven't done that here. So we're stuck with 10.1, we're stuck with 12, and this court has to apply it. Now, finally, there's the argument that there's no live dispute. Now, firstly, and it's the last domestic case in our bundle of authorities, which my Lord will find the relevant passage at 228. This is Hoskin versus Competition Commission. Now, my learned friend cited this in his heads of argument as authority, where he cited the Competition Appeal Court case as authority for the proposition that you can't decide live disputes. It begins at page 196, Competition Commission versus Hoskin, and that's of the bundle in your hand.
That's the bundle?
That's the bundle, yes, my Lord. Page 196, it's a Constitutional Court judgment in Competition Commission versus Hoskin. Now, my learned friend referred to Hoskin in his heads of argument, the Competition Appeal Court judgment, which was overturned on appeal to a large measure in the Constitutional Court. And the Constitutional Court held at paragraph 82, which is on page 228, that in fact, when you're seeking a declaratory order, you don't even need a live dispute. But in any event, and more importantly for the present case, on page 229, in paragraph 85, the court felt that a difference of opinion on the law is a live dispute. The court was persuaded that there was a live dispute between the parties because the mere fact that...
paragraph?
This is paragraph 85 on page 229.
Yes.
The mere fact that the parties had a difference of opinion regarding an important jurisdictional issue suggests that there was a live dispute. And the live dispute in this case is clear from the papers. We know that the flag was waved on Black Monday. It was hung over a bridge and displayed in a variety of other manners and places that are on the papers, that are not challenged. Now, the dispute arises as follows. This display of the flag happens. It wasn't hypothetical. This message of hate was not hypothetical. It was real. It was visceral. And the hurt experienced by Mr. Hatang on the basis of group identity as a black person in South Africa is wounded in his dignity and his equality. And that hurt is not hypothetical. It's real and it's visceral and it's on the papers under oath and it's unchallenged. The only answer that AfriForum provides to that is that he needs to suck it up. He must be less sensitive. He must reflect on how far the country's come. FRK takes it even further, says, no, well, he must leave it to the marketplace of ideas. He's got no business concerning himself with the courts over this grievance. Now, the dispute arises then as follows. Mr. Hatang says publicly that what happened was legally wrong. The flag being displayed was legally wrong. What I experienced was legally wrong. There ought to be a remedy. Mr. Creel for AfriForum says no. It's not legally wrong. So we go to court. We have a difference of opinion on the law. The only reason we have no dispute of fact is because Mr. Hatang's testimony on what happened and what effect it had is unchallenged. Even though at the time, before the papers were filed, AfriForum said, no, it never happened. When it came down to putting versions under oath, they had no answer to Mr. Hatang. So we have a concrete factual background to a concrete legal dispute, which is properly before the court and requires a remedy if Section 10.1 is satisfied. The concern then is that, no, what we're seeking is not to resolve something that's happened, but to seek an order with prospective effect. Now, there's nothing unusual about that in the Equality Court. The Equality Courts are special. My learned friend, Mr. Oppenheimer, told us how they're special in Manong. They are special purpose vehicles. Now, sorry, that's from Koelane, Van Oosten's judgment. They're special because they're designed not simply to resolve ordinary disputes between man and man, but to stamp out racism. The language used in Section 2 is to eradicate unfair discrimination, harassment, and hate speech. To eradicate. And there are many judgments in which the Equality Court, this court, has held that there is a line to be drawn in as irony would have it, AfriForum versus Malema. Justice Lamont said, this is the line. I can impose an interdict against Mr. Malema, but I can also give a declaratory order saying that it is hateful to sing this song. Yet AfriForum, when the shoe is on the other foot, says no, you can't have that kind of remedy. And FRK says no, you can't come here with abstractions. Even though in that judgment, and we have a precedent, and that precedent hasn't been challenged by our learned friends, to say that this message is hateful. Not, oh, but we're not sure about the context. They're happy in that case to say, no, well, Section 12 is enough. But when it comes to displaying the old flag, no. Then you can't seek a declaratory order. You need to find an individual and sue an individual and get some kind of civil justice against him. But you can't seek, as the Act says we can seek, to eradicate the expression of this message of hate. If my Lord has no questions, then those, I hope I've been as brief as I was meant to be.
Thank you very much.
Thanks.
Yesterday, Mr. Turnbull described my submissions as overly generous to AfriForum. I want to continue the spirit of generosity. We have not come to ask AfriForum and its supporters to stop racism and to stop their own racism. We have not even come to ask that they should stop grooming their children to become racist and white supremacists. If they want to, that is their choice. No law can stop people from becoming racist. No law can say to a parent that you may not groom your child to be a racist. What we've come to do is to stop them from speech that dehumanizes black people on the grounds, as Mr. Wing says, of group identity, on the grounds of race. We've come to assert black people's dignity. We've come to assert black people's right to equality. We have come to assert black people's right to freedom, all of which were denied under the apartheid state, and all of which the apartheid flag is a salient reminder. Let us pause to reflect what this flag represents. It is a collective experience or collective experiences of the white race, which comprised, as pointed out yesterday, Malan, Smuts, Herzog. They were quite clear in what they wanted to do. South Africa would become a white state. There would be no place for the black man other than a place of subservience under the control of the white man. This is precisely the kind of historical reminder that they are unable to dispute. Mr. Trengov reminded us also yesterday that not only does the flag have historical difficulties associated with it, Mr. Kari underplays it and calls it problematic. It's a history of white domination, not just a problematic history. On both of those, the historical and the contemporary, AfriForum is simply not able to offer an answer. What is most telling is their failure, my Lord, when you point to them. What is the point you are trying to make by displaying the flag? They are simply unable to answer. But let us remember that despicable crimes were committed in the name of apartheid, quite apart from the fact that apartheid was a crime in itself. Let us remember the Group Areas Act. Let us remember the Native Administration Boards. Let us remember Steve Biko. Let us remember Sobukwe himself. But this is not a black and a white issue. Let's remember David Webster. Let's remember Neil Agate. All of these were compatriots committed to the South African cause, even before 1994. And this was never a white and a black issue. It was, as the international community pointed out, a question of humanity. And so, my Lord, when the Nelson Mandela Foundation comes to your Lordship to ask for a declaratory order, not a ban, as it has been derisively referred to by AfriForum, when the Mandela Foundation comes to your Lordship to ask for a declaratory order, what it is simply asking to do is an assertion, an affirmation that black people count. And so, this is not a difference of opinion. Mr. Oppenheimer's constant refrain that in the world of democracy, opinions, even those that are offensive, views, ideas must be expressed. When he does so, what he actually does not appreciate is that dehumanizing speech is not about opinion. It is about the denial of humanity. And so that is what apartheid ultimately represents. And so the flag is the most visible symbol, not just of white supremacy, but the most visible symbol of the dehumanizing effect that apartheid became. And so after the couple of hours that Mr. Oppenheimer undertook to address us on, we are left completely unilluminated about precisely what their intentions are. We are therefore forced to read between the lines about what they want to do. Not only do they yearn for the return of the good old days, what they yearn for is the idea of a white man being master, the bus ideology. This is what they have come to assert to court, period. And we should stop pussyfooting around the truth. Mr. Curry, I listened to him carefully as he was addressing. The fact is that he dances around the reality because they are unable with a straight face to tell your lordship what the point is that is served by the display of the apartheid flag. We are therefore forced to take them at their word. Two of the people who attended Black Monday, Dan Roth, he said his only regret about the old apartheid flag was that it contained the British Union Jack, and he preferred it as a combination of the Transvaal and the Orange Free State flag. The other member told us, it's all on affidavit, that the reason I keep on with this flag, it is because I felt safer under apartheid. And even today and yesterday, we listened to Mr. Oppenheimer, we listened today to Mr. Curry in defense of the apartheid flag. Whatever they want to sugarcoat their submissions, the fact of the matter is that they're defending the display of the flag. We listened to their submission. What was missing from their submission? It is most striking. It's dignity, the references to dignity. What is also missing from their submission is the reference to equality. In other words, black lives are still missing from the articulation of the law by AfriForum. What we know on the law is that the freedom of expression is not sacrosanct. The freedom of expression does not trump each and every right. There is no freedom to be, as they claim, a freedom to assault one's dignity. This, again, is not a new proposition. This is a point made by the Constitutional Court in the case of Khumalo and others versus Olomisa. I'm told your lordship does not have copies of this judgment. If I may hand up a copy and refer you to one passage, paragraph 25 of the judgment. And it helps us because it situates these rights in the proper constitutional context. If we are to take AfriForum seriously, the only right that is protected under the Constitution is the right of racists to assault the dignity of black people on the grounds of their race. But we don't have to go there because the Constitutional Court has given us guidance. Paragraph 25 makes the position clear. This is what Justice Cato Regan said. However, although freedom of expression is fundamental to our democratic society, it is not a paramount value. Underscore, it is not a paramount value. It must be construed in the context of the other values enshrined in the Constitution. In particular, the values of human dignity, human dignity, freedom, and equality. So in other words, freedom of speech is itself constitutionally constrained. It does not exist as a supra-constitutional norm upon which everything else is subservient. It is constrained primarily by dignity, it is constrained primarily by freedom, it is constrained primarily by equality. And dignity and equality are important constraints to to expression, because these are the markers of the colonial state and the apartheid state. It is important to regulate speech which would assault people's dignity. It is important to regulate speech that would assault people's rights to equality. And here, my lord, we know these values because they come from Section 1 of the Constitution, they come from Section 36 of the Constitution, and they come from Section 39 of the Constitution. They are not called foundational values for nothing. And there is a reason why expression is not put as a foundational value, but dignity and equality are foundational values. Constitutionally speaking, what that means is that when we interpret expression, we must do so through the prism of dignity and equality. We cannot ultimately interpret expression in a way that allows the indignity visited upon black people, in a way that promotes inequality among black people. And of course, it is true that speech in and of itself may not violate in particular context dignity and may not violate in particular equality. But this is not just any form of speech or any form of expression. This is the expression of the most visible symbol of what it meant to be white under apartheid and what it meant to be black under apartheid. And so we are not debating with AfriForum whether or not there should be ideas that should be driven underground. We are not debating whether or not the Springboks should remain as the emblem of our national rugby team, which might qualify as a question of ideas. What we are debating about is whether or not the most important symbol of the apartheid state should continue in post-apartheid South Africa. Yes, it is true, this is something the legislature should have resolved long ago by passing legislation. But, my lord, we live in a state where this sort of thing sometimes needs to be brought to court. So that context is vital to understand this. It is not as if expression trumps everything. Expression itself is subservient to dignity and equality. And so the foundation has come to court to say that it is time for the court to recognize that the dignity and the equality that are promised must be translated into reality. The legislature has done the function for most of us, for all of us, in telling us precisely in what mechanism can I give effect to equality and dignity in the context of speech. It has done so, Mr. Wings pointed out, by Section 10 of the PEPUDA. It has done so also by Section 12 of PEPUDA. And so it is important to remember that everything that Mr. Oppenheimer spoke about as a possible justification for the use of that flag is covered in Section 12. Anything that is not covered in Section 12 simply means that there is a legislative lacuna. But it is not up to this court to resolve that legislative lacuna. It is up to AfriForum to go to the legislature, ask for an amendment, or to ask for the legislation to be declared unconstitutional. There is not a single proposition that they put where they can say Section 10 is not good enough and Section 12 is not good enough. We must take both sections to be valid and therefore capable of judicial interpretation and judicial enforcement. And so, my lord, the point of the matter is, strictly speaking, under the Equality Act, we know what speech is allowed and we know what speech falls outside the parameters of the Equality Act. And that is why I come now to the third point. That is why the choice of the word gratuitous is not a mistake. Because by saying gratuitous, we seek to delineate that form of speech that does not have legislative protection under Section 12. And we know precisely the kind of speech that enjoys legislative protection under Section 12: artistic creativity, academic or scientific inquiry, fair and accurate reporting in the public interest, and then publication of information in terms of Section 16. All of those are legislative choices that have already been made for us. And the legislature has not been wrong in making those choices, because your lordship remembers from the judgment of Islamic unity, paragraphs 30, 31, 32, and 33, where in particular in paragraph 33, this is what Justice Langer said. He first describes what Section 16 is about, and then he says, in relation to speech outside of Section 16, there is no doubt that the state has a particular interest in regulating this type of expression because of the harm it may pose to the constitutionally mandated objective of doing what? Of building a non-racial and a non-sexist society based on human dignity and the achievement of equality. There is accordingly no bar, he said, to the enactment of legislation that prohibits such expression. In other words, already the Constitutional Court recognized that there would be instances where the legislature wants to regulate, in fact, in this case, prohibit, not even regulate, wants to prohibit expression that is in the form of an assault to the non-racial character, non-sexist character, and human dignity and achievement, all of which are foundational values to the Constitution. And then he continues, Justice Langer, any regulation of expression that falls within the categories enumerated in Section 16.2 would not be a limitation of the right in Section 16. So we know already that it was envisaged long ago that Section 16 on its own might be supplemented by legislation which would go outside of the bounds of Section 16. And the only test then would be whether that legislation is justified under Section 36 of the Constitution. So perfectly nothing constitutionally objectionable in having Section 10 regulating this form of speech, and also nothing constitutionally problematic in having the 4 categories listed in Section 12 of the Act as the only bar against which one may not use the apartheid flag. So gratuitous is a deliberate choice because it's expression that does not fulfill any of the preconditions in Section 12. There is no reason advanced why expression that does not fall within the exceptions in Section 12 should be allowed, especially in the context of the apartheid flag. What is stated, and this is a point made yesterday, is that when you say gratuitous, you are being too wide because you've got the potential of inhibiting people in their homes from displaying the flag, and that racists should be allowed to display their flag in their bathrooms and in their homes. But that, my lord, is made by someone who probably has no experience of South African life. In South Africa, white people, although they dominate black people, but they live alongside black people. There is no home that does not have a domestic worker, no home that does not have a gardener, and no home that does not have visitors. And the idea that you can somehow insulate this flag by displaying it in a bathroom does not answer the question of the gratuitous display. So ultimately, as long as there is a potential, a possibility, a probability that black people who are offended by the display of the flag will come into contact with it, it is permissible for the court to effectively declare those displays as unconstitutional. So the distinction that's drawn between private and public is an illusory distinction in the context of this case. The ultimate test is whether or not there is a risk, not an imaginary risk, but a real risk, because we know of the social context in South Africa. Whether there is a risk that people who may find the flag offensive will come into contact with it. It does not help for us to say, I'll display it in my bar, or I'll display it in my bathroom, because by doing so, of course, you are grooming your children to become white supremacists, but you are also causing offense to African people that work in the most instances as domestic servants or sometimes as gardeners. And it is important to lay that law in particular, because if one looks at the asymmetry of power that exists in the domestic settings, it's precisely why there must be a declarator. It is to protect those domestic people that do not have the same powers that we have to come to court. It is precisely because if this is allowed, that asymmetry of power ultimately leads to domination. And so that is why we cannot accept the distinction that AfriForum seeks to draw, that says in the privacy of our homes we should be allowed to display these flags. And we must always remain with the ultimate test. Any display that does not fall within the parameters of Section 12 is not allowed by Section 10. It is therefore hate speech for that purpose. That takes me then to the order that we seek. Oh yes, and of course, I think the Mandela Foundation would be very upset if I didn't rescue Mr. Mandela from the intellectual assault that he suffered yesterday. He was quoted, and unfortunately misquoted, as it usually happens. There is a speech that Mr. Mandela gave at the University of Pretoria on the 29th of April, 1991. And I'll give a copy of the speech to your Lordship at the end of this proceedings. 28 years ago, and it explains what Nelson Mandela's true position was on racism. And I want to quote only 2 passages. He says to the white Afrikaner students at the University of Pretoria, "We have vowed to rid this land of racism and to bury it once and for all, with everything else that has meant dehumanization for the majority of South Africans for so long." Mandela's vision, therefore, my lord, of reconciliation was not tolerance of racism, but it was its uprooting and burying it once and for all. It was confronting the dehumanization of the majority of South Africans and fighting against it. And then he continued, if you value the privileges that go with racism, that depend on the blacks of this country being downtrodden, then you have reason to fear. We want equality, and we will settle for nothing else. And so this idea that Mandela preached tolerance, Mandela preached reconciliation, is distorted if it suggests that what Mandela preached was tolerance of racism. Mandela wanted racism uprooted, confronted, and buried once and for all. On the interpretation and the meaning, my Lord, I want to repeat, there is no dispute on the historical meaning, and there is no dispute on the meaning that was articulated by Mr. Trengov on the contemporary uses of the flag. If we accept both of those meanings, the historical meaning that I explained yesterday and the contemporary meaning that was eloquently described by Mr. Trengov, if we accept both of those meanings, then of course the display of the flag is racism, period. And therefore, there is no scope within the parameters of Section 10 to continue allowing the racist displays of the flag, invoking, rather perversely, Mr. Mandela's legacy. And so, where do we remain then? That leaves me with two more suggestions. The one is to refer your Lordship to the Section 12 racial discrimination complaint. You will recall that I made yesterday the point that there was no debate on Section 12. Section 12 of the Act says, no person may disseminate or broadcast any information, regardless of whether it's words or any information, publish or display any advertisement or notice that could reasonably be construed or reasonably be understood to demonstrate a clear intention to unfairly discriminate against any person. The display of the flag, of course, demonstrates a clear intention to discriminate, because it is precisely the kind of nostalgia that Mr. Trengov spoke about, the nostalgia for apartheid. And so, under Section 10 and under Section 12, the display of those flags are prohibited. And so that's the point we made yesterday, that both Section 10 and Section 12 are implicated in this case, especially if the meaning that we proposed is accepted. And so, to come back then to the end of my submissions, it's utterly fallacious to regard this case as a case about contested meanings. This is not a case about contested meanings. It is not a case about contested ideas. It is a case about a group of people that have decided that they will not embrace the new South Africa and they will continue with the ways of the past. The law says that this should not be allowed, especially in instances where it is hateful, hatred, and constitutes a propagation, or sometimes constitutes a propagation of hatred based on race. We made our submissions yesterday about the disjunctive. I don't want to repeat those submissions. We simply insist that on a correct interpretation of the law, the phrases are disjunctive and hatefulness is sufficient. That leaves me then to one issue, which is the order that we want to submit to your Lordship. And I have copies here of the order. I want to also speak about this order because it has been a subject of much distortion about what case the Nelson Mandela Foundation has actually brought. Yeah, I gave it. Thank you. Yes. So, if your Lordship has regard to paragraph 1 of the order, and alongside that, your Lordship can have regard to section 21 of the Equality Act.
Yes.
Thank you, my Lord. So alongside this, so your power under section 21 sub 1, the Equality Court before which proceedings are instituted must hold an inquiry, we've held an inquiry, in the prescribed manner and determine whether unfair discrimination, hate speech or harassment has taken place. On the facts we know the foundation complains pertinently about Black Monday. And on Black Monday alone, Your Lordship is at large to make a determination whether those displays constituted hate speech, harassment, or unfair discrimination. In paragraph 1 of the draft order, we say Your Lordship should invoke Your Lordship's powers under section 21 sub 1 of the Act and determine whether or not hate speech took place as a consequence of those displays of the flags. We might recall the facts in this case. We might recall that AfriForum keeps on telling us we don't encourage, and this is Mr. Kari's sell to the court. No one has any particular love for the flag. The flag has no currency. No one wants to display the flag. That ignores the facts. The flag was displayed. AfriForum did not discourage anyone from displaying the flag. Instead, they denied that the flag had been displayed. And this idea that there is no likelihood in the future of the flag being displayed is simply belied by the facts. AfriForum has not pointed to one example, where a flag has been attempted or displayed at their events and they stopped that person. The one example that we have brought is common cause. The flag was displayed. Gary Grill and Ernest Rhodes subsequently lied and said it had not been displayed. So there is no reason why Your Lordship cannot, on the facts, determine that under section 21(1), as we ask for in paragraph 1 of our order, hate speech has occurred. What then that leaves us is what we should do about the future. What should we do about the future? Should we confine ourselves to that particular instance in the light of what we know and in the light of the facts that have subsequently been pleaded and the case that has been made? We know, contrary to everything that Mr. Kari says, and by the way, half of what Mr. Kari was saying is not even pleaded, because they never pleaded this point about the lack of a live dispute. They entered the fray and disputed our interpretation. And now, much later, after we showed them that historically what they are saying is fallacious, they now come in with an argument that, oh no, sorry, there's not even a live dispute. But what is the ultimate end point? The ultimate end point is do not prohibit racists from assaulting the dignity of Black people. And why we know that to be so is when Your Lordship asked probably the most important question in these two hearings to Mr. Oppenheimer. What are the instances when you would like to display the flag? What Mr. Oppenheimer ultimately said after 3 attempts at answering Your Lordship was all instances. In other words, they want the flag to continue being flown. And so, the future is as important as what transpired on Black Monday, which is why we have paragraph 2 of our draft order. And paragraph 2 flows from section 21(2), the powers that you have under this act. So we don't really understand the arguments that have been made here about the powers of this court and its limitations, because these powers are expressed. 21(2), after holding an inquiry, which we have done, the court may make an appropriate order, which we are asking for, including B, a declaratory order. And so we are asking here in paragraph 2 that you must make a declaratory order so as to regulate the future conduct. Mr. Winks made the point quite clear that the powers of this court are unlike your typical high court powers. These are wide powers. These are inquisitorial powers, because these are powers that are meant to regulate something of social concern, like racist speech that assaults people on the basis of their group identity. And so that is why we say in section 21(2) of the Act, that should be the order made. That obviously doesn't detract from the fact that we are asking for an order pursuant to section 21(1). And so in our own pleadings, the affidavit of Mr. Hatton makes the position quite clear, where at page 10 and 11, so firstly, Mr. Hatton explains in paragraph 7 and 8, 9 and 10, but at paragraph 11, he then explains the background, what happened, 11, 12, and 13. I referred to 13 yesterday in a different context. He explains the impact of the flag on him and why that display on that particular occasion And the display is described on paragraphs 11 and 12. He explained that display on him. And so the facts are quite clear, the facts that are necessary for the declaratory order. And then later on, of course, the case is made not only for Black Monday, but a future prospective order. And so there is just no basis for the suggestion that the foundation has come to ask for an abstract prospective order that has no relation with the facts. And it's been repeated by Mr. Curry this morning. And yet, on the pleaded case, it's quite clear that there were two complaints that were made by the foundation. The one complaint was that Mr. Hatang says, I was offended about the display on Black Monday. And then he said, but I don't want to see this flag again in the future. And that's why we've made it clear in the order that both 21.1 and 21.2 of the Act should then guide your Lordship in exercising your powers. With this order, there will be no debate in society, and there will be no doubt in society about what can be done and what cannot be done. Everyone reading your Lordship's judgment will know that the only displays that are warranted are displays under Section 12 of the Act, within those four categories. Everyone will know that I may not expose my gardener to my own racism. I should keep my racism for my children. What of course will not be decided is whether a particular display at a particular moment is hate speech. That obviously will require, as Justice Lamont found in Dubulibun, that would require a new application to be brought against a specific display on a specific occasion. And this is a point made at length in the context of Dubulibun, that yes, the singing by Mr. Malema was problematic, but any other singing by anyone is problematic. But whether or not a singing in a particular context which may be contested, when someone says, yes, I sang Dubulibun, but it was because I was giving a lecture at Wits, whether that would constitute hate speech will depend on a case-by-case basis. So there should be no confusion about the remedy. The remedy we seek is a cut and paste of the remedy that AfriForum got against Mr. Malema.
Just before you proceed, you pointed me to the paragraphs where he makes a case
Yes.
for past displays.
Yes.
Where is the case being made for the future? You said, I thought you...
Oh, yes.
you had about
Yes. Sorry. The reason I didn't refer your Lordship is because I took it to be admitted that a case is made for the future.
It's just that you said you are going to take me to it.
Yes. No, I accept that, my Lord. It is in page 16. Paragraph 21, 22, 23,
Yes.
and 24. And paragraph 24 might just be read into the record because it encapsulates both the past and the future.
Yes.
The Equality Act empowers equality courts to fashion appropriate remedies for behavior that undermines equality and human dignity, such as apologies, community service, and sensitivity training. Gratuitous displays of the old flag are egregious examples of such behavior and should be met with these remedies. But Black Monday and the resulting dispute that erupted between the Foundation and AfriForum has revealed the need for a declaratory order to this effect. Otherwise, many potential perpetrators and victims of this discrimination, hatred, and harassment will remain unaware of where the constitutional boundaries lie. And then the Foundation then says that we pray for a declaratory order. But the future case is made from 21, 22, 23, and 24 then summarizes the position. It speaks specifically about the need for a declaratory order in relation to Black Monday and the need for a declaratory order about potential future displays. So the case on the facts is completely made, and the attempt at arguing that we haven't made the case on the facts is completely discredited. And so we remember, finally, my Lord, that the reason we need both the backward-looking order, that what they did on that occasion was wrong, and what they may potentially do in the future is wrong, is because we remember what the spirit of the Constitution is. We cite this in paragraph 22 of our heads of argument, where we say, and this is a point made by Chief Justice Mogoeng in Gavas, finally, a lesson from our history, as underscored by the Constitutional Court in Gavas, is worth repeating. Ours is a never-again constitution. Never again will we allow the right of ordinary people to freedom in all of its forms to be taken away. Thank you, my lord.
Lord, my learned friend has handed up a draft order which seeks relief that is different from the relief sought in their papers. I know it is unusual for a respondent to speak, but new matter has been introduced and it warrants an answer. My lord, paragraph 1 of this draft order seeks that it's determined that the display of the old national flag of South Africa at the Black Monday demonstrations be declared to be hate speech. Now, my lord, the case that was brought by the Mandela Foundation was not that case. At page 16 of the bundle, they set out,
or 16?
page 16.
16.
Yes. They set out the relief that they seek. Paragraph 23, it says, the Foundation respectfully submits that any gratuitous display of the old flag contravenes the Equality Act in 3 ways. It's unfair discrimination, it is hate speech, it is harassment, and they seek a declaratory order to this effect. They do not state here that they seek an order regarding the Black Monday protests. What they say about Black Monday is in their background section, and that background explains the dispute between the parties. So at no point is it ever alleged in these papers that AfriForum ever waved their flag. The claim is that there was a dispute between Kali Kriel and Selahotang about whether the flag is constitutionally protected or not. There is a legal dispute. There is no dispute that, in other words, it is not alleged that AfriForum waved the flag and we want to declare it against AfriForum for waving a flag. That is not their case. Now, there have been intimations that this is their case. They've said Dan Ruert made a claim about how the old flag has the bloodstain on it. Dan Ruert is not an AfriForum member. There's another claim about some other unknown protester who says the reason why they waved the flag is because it makes them feel safe. There's no allegation that that person is an AfriForum member. There is no allegation at all, at any point in time, that AfriForum waved the flag. And to then cite AfriForum on the basis that there's a legal dispute, well, they wanted to make allegations about particular incidents at Black Monday, or they needed to cite people that waved the flag. They need to run that particular case. They should have tracked down people that they allege waved the flag at that particular instance. There is no such case like that before this court. The relief sought in 1 of this paragraph is entirely different from that which is sought in their papers. They must confine themselves to the case they brought before this court, which is simply that there is a dispute in the law about whether the flag prospectively constitutes hate speech. And in other words, whatever relief they seek can only be contained to that. And as I've addressed already, there are a range of reasons why they're not entitled to that particular relief. There are other new material that was put forward by my learned friend. My learned friend, there were some other new facts put forward by my learned friend. My learned friend states that AfriForum grooms their children to become white supremacists. This is an allegation not made in their papers. This is an incredibly inflammatory thing to say about an organization that is not in their papers. And that kind of statement must be understood in its light as really for effect, but not grounded in any fact. That is the kind of statement that is injurious to the reputation of AfriForum made without any factual substance. To imply that AfriForum has an interest in waving this flag, that when it has been said on a number of occasions that they have no interest, that their interest is in the right to freedom of expression, to keep eliding that point to say that what I'd said earlier was that we want to wave the flag in all instances. That is not what was said. What was said is that all instances of the flag are protected unless there is a particular context in which can be shown that they reach the thresholds in Maputo. To make the claim that there is, in other words, there is a difference between saying one wants to waive it and saying that I don't want to waive it, but I accept that it's protected. There may be a whole bunch of things, a whole bunch of flags that people don't want to wave because they find them disgusting or repugnant, but nonetheless think are protected by the law. So it's important that the record is set straight in that regard.
I think, unusual as it is, it's an assertion, an answer, it calls for a reply.
No, my lord, it doesn't deserve a reply.
Lord, I'll address three topics briefly. Firstly, the interpretation of Section 10.1 and the word words. Secondly, the court's jurisdiction to entertain the constitutional challenge to Section 10.1 in the alternative. And then lastly, the debate so eloquently addressed by all my learned friends on the approach to this matter, whether from the vantage point of freedom of expression or from the vantage point of freedom of expression, dignity and equality. May I start with the first issue, the interpretation of Section 10.1. I will make merely 2 points. Firstly, my learned friend Mr. Oppenheimer referred you to my client's founding affidavit in which it asserted that that Section 10.1 is limited to words and does not extend to expression. That is true, but that was wrong, and it's irrelevant. And it's irrelevant because the law is, and the SCA has held and subsequently reaffirmed, that interpretation is a matter for the court and not the witnesses. If I could give you the reference, it is KPMG v. Secure Fin, 2009, Volume 4, SA, 412, SCA, paragraph 39. My learned friend Mr. Oppenheimer secondly suggested that the Malema case is precedent in support of their interpretation of their restricted interpretation of the word words. But that is not so at all. The court in the Malema case was not concerned with that issue at all. It was concerned with the question whether the singing of Kill the Boer constituted hate speech or not. And His Lordship, in passing, merely noted that the section refers only to words and not to other forms of expression. But he didn't engage on an interpretation of that word at all. So the case isn't authority for anything relating to the proper interpretation of that word. May I deal secondly with the question of jurisdiction. The jurisdiction of this court to entertain my client's challenge to Section 10.1, if it is interpreted against us to be confined to hate speech by words and not hate speech by other forms of expression. Now let me just make it quite clear, of course, our primary submission is that the section is constitutional because on its proper interpretation it extends to all forms of expression and not only expression by words. So this whole debate about the jurisdiction will arise only if you find against us on the interpretive issue. If you get there, then let me concede that the Equality Court only has such powers as are conferred on it by the Equality Act, and that it does not include the power to declare legislation invalid. But the question then arises what one does if you have a case such as this one, where the primary claim is subject to the exclusive jurisdiction of the Equality Court, but the alternative claim is beyond its jurisdiction. How does one cater for a case like that? Well, the Constitutional Court addressed the issue in De Lange's case. If I may hand up an extract of De Lange. It is De Lange v. Methodist Church and another, 2016 2 SA. My page number has been cut off, but I think it is page 1. It deals from paragraph 53 with this very issue, because in that case too, the question arose whether Ms. De Lange could have gone to the Equality Court, seeing that she had an equality claim, but also a contractual claim. And then in paragraph 56, the court dealt with it as follows. In a trilogy of cases, the Supreme Court of Appeal took the posture that the Equality Court is a special purpose vehicle and a creature of statute deriving its powers from the Unfair Discrimination Act. It existed separately and distinct from the High Court. The Equality Court considered whether a consolidation of claims falling within the distinct jurisdiction of the High Court and Equality Court is permissible. Now when they refer there to the Equality Court, that's the Equality Court in the Kwalani case. That's His Lordship Mr. Justice van Oosten's judgment. The Equality Court considered whether consolidation was permissible, made reference to the case of George, where the Supreme Court of Appeal had paved the way for consolidation. And they quote the SCA as saying, the question of double jurisdiction in this case is not unique and is likely to arise in every case. There is no reason why those who have interrelated remedies under the Unfair Discrimination Act and other legislation should not be entitled to pursue their remedies in parallel proceedings before the High Court in its capacity as an equality court and the High Court in its ordinary capacity. Given the problem of concurrency will inevitably occur, the most productive and expeditious way of achieving efficiency would seem to lie in the matter being referred to the same High Court judge who, in his capacity as an Equality Court judge, is presiding in that court. In George, it was held that the Equality Court proceedings and constitutional challenge proceedings may be consolidated for hearing before a single judge sitting as an Equality Court and as a High Court. There is indeed much to be said for this approach of permitting consolidation of disparate claims before the High Court. The consolidation will not only serve the procedural requirements of unfair discrimination, but will also avoid piecemeal litigation and costs. It seems to me that on this Supreme Court of Appeal authority, the consolidation of disparate claims was quite permissible, etc. So it is quite permissible to bring before your Lordship two claims, one falling within the exclusive jurisdiction of the Equality Court and the other one falling beyond its jurisdiction but subject to the jurisdiction of the High Court. Now, in this case, we submit that my client, the Human Rights Commission, brought a separate application, and it made one mistake. It said in the heading, Equality Court, instead of saying High Court. If I may ask your Lordship to go to the record in this case at page 218. That is my client's notice of motion by which it joined these proceedings. And you'll see it says in the heading, the Equality Court of South Africa, Gauteng Local Division, Johannesburg. And I accept that the Equality Court is not the court with jurisdiction in the alternative claim. They should have said in the High Court of South Africa, not in the Equality Court. But if you look at the substance of this notice of motion, not just the heading, it doesn't follow the substance prescribed by the rules of the Equality Court. It doesn't employ the standard form that one employs for lodging a complaint with the Equality Court. It is, in every material respect, a High Court notice of motion. It cites the minister, who wouldn't have been cited if this was merely equality court challenge. The form of the notice of motion is pure Rule 6 of the High Court rules. It follows the standard form of a High Court notice of motion. So it is in every respect a High Court notice of motion, except only that it says at the top, Equality Court. And then after the notice of motion, there also follows at page 223 the founding affidavit. Again, stock standard High Court application, except that it says at the top, the Equality Court. So we submit with respect that it was a mistake to formally lodge this as a Equality Court process. But that is form. As a matter of substance, it is a notice of motion supported with a founding affidavit, substantively identical to a High Court application, in which not only the offender is cited, but also the minister, as one does in a standard application, which makes an attack on parliamentary legislation. So, on this issue of jurisdiction, we concede that the Equality Court does not have jurisdiction to entertain the claim. And although the application has been brought in name in the Equality Court, it is, as a matter of substance, a High Court application, and we will ask your Lordship to condone the mistake and treat it as a High Court application. Neither of the defendants, neither the Minister nor AfriForum, raised any objection to the jurisdiction of this court. So that, and I'm not suggesting that the absence of an objection confers jurisdiction on you. But what I am asking you is that when the matter is in substance a High Court application, and we ask for condemnation for the mistaken identification of the matter, then the fact that neither the respondent took any objection to the matter is a further consideration in favor of forgiveness of the mistake. May I deal lastly with the matter which has been very fully and very eloquently and compellingly addressed by my learned friend Mr. Kaitobi. And that goes to the approach of both AfriForum and the FRK, both of which urged on you to determine this case as if it was one brought under and to be adjudicated by the right to freedom of expression. And as my learned friend Mr. Kaitobi made clear, that freedom, everything my learned friend Mr. Curry said about freedom of expression and the magic of the marketplace of ideas that will look after offensive speech, everything is true as far as it goes, but it is one part of a three-part story. Under our Constitution, as my learned friend Mr. Kaitobi said, freedom of expression does not stand alone and untrammeled. The Constitution does not leave it to the marketplace of ideas to weed out offensive speech. The Constitution, in fact, demands that the dignity of every person be respected and be protected by the government. The Constitution also demands that, or prohibits, unfair discrimination and demands that the state protect victims against unfair discrimination. So this is not a one-horse debate race. This is a debate which seeks to draw a balance between three compelling constitutional values which pull in different directions. So it is quite wrong to do as our learned friends have done, to suggest that this is a freedom of expression debate. But my Lord, I can't say it better than my learned friend Mr. Kaitobi has done. But can I take it one step further? the approach is moreover wrong, because this is not a case being brought under the Constitution. This is not a case that requires you to strike a new balance between those three constitutional values. Parliament has already done so. Parliament has done so in the Equality Act. Its very purpose is to strike a balance between these three constitutional values. And the question before you today is not where the balance should be struck, but simply to apply the balance that Parliament has already struck. And that simply means to ask whether the gratuitous display of a flag by which people are demeaned and degraded constitutes hate speech under Section 10. And we submit with respect that to that question there can only be one answer. Thank you, my Lord.
Gentlemen and ladies, thank you for your submissions. They do require some consideration, which I will do. No doubt all your submissions will be of great assistance. Judgment is reserved.
So